If we win, we will have established a new case law in this area that will roll back the authority of the health colleges in Ontario. And I think it will also generally roll back the authority of the administrative state in the province. So I think it will have a huge ripple effect. Also, if our arguments around free expression are accepted, we will have established a more comprehensive and more grounded way to look at the freedom to express a minority opinion, which is guaranteed under the right to free expression in the Charter.
The case of ousted Ontario physician Dr. Mark Trozzi holds the power to redefine free expression and justice in medicine in Canada. A relentless pioneer in challenging the official COVID narrative and handling, Trozzi first made headlines in May of 2020 when he exposed the reality of empty hospitals, directly contradicting the mainstream media and political claims of a crisis-ridden healthcare system at the time. Despite facing censorship, he has remained steadfast in his pursuit of truth and transparency ever since, but it has come with great cost. He has been stripped of his license to practice medicine by his regulator, the College of Physicians and Surgeons of Ontario, also known as the CPSO. Ever since, they compelled doctors to abide by public health messaging or else. After a prolonged investigation by the CPSO, a disciplinary tribunal ruled Trozzi guilty of professional misconduct last fall for allegedly spreading misinformation and daring to write medical exemptions for patients pressured into taking the novel modified RNA COVID-19 injections. Armed with over 3 decades of experience in constitutional and administrative law, his lawyer, Michael Alexander, has appealed the decision through the divisional court and joins me now to discuss how that proceeding went. Let's have a listen.
We had a really good day in court. This is the first time in 3 years that I've appeared before a panel on these COVID issues where the panel was not openly biased against me and my client. So that was a good sign. My time was cut down from 1.5 hours to 1 hour, somewhat arbitrarily, but I scrambled and I managed over the course of the hour to get our core submissions out. My strategy was to focus on our cross-examinations of the college's expert witnesses at the tribunal hearing because I pretty well took down their expert witnesses on cross-examination. In fact, I took their main witness on COVID science, who claimed that Dr. Trozzi was spreading misinformation and causing public harm. And I turned him into a witness for Dr. Trozzi. And over the course of the cross-examination, got him to admit that essentially he agreed with Dr. Trozzi on the basic points of COVID science that were at issue in the hearing. But what happened afterward was the tribunal completely ignored my cross-examination when it wrote up the decision. So that is a violation of due process. It's also what's called in law a palpable and overriding error of fact. It's a failure to consider and weigh material evidence. And so, the college's other main expert witness, Dr. Noni MacDonald, I went through some of her cross-examination too, and she admitted at the end of the cross-examination that the report that she presented about the harms resulting from misinformation in public health, she admitted at the end of that she didn't know who Dr. Trozzi was and didn't know what he did. So that pretty well scuttles her testimony. And so I also went after what the college tried to do to Dr. Peter McCullough, who was our main expert witness, and they had a completely absurd cross-examination of him, performed by one of the college's lawyers, in which he took the position that Dr. McCullough wasn't credible because sometimes he took passages from articles or books and included them in his own work, but did not agree with all the conclusions in the articles from which he took the quotation, and therefore must be in contradiction somehow. But I mean, every high school student knows that you can take a quotation from a book or an article without necessarily endorsing the conclusions or all the points made in that article or book. I mean, it was just a strikingly jejune approach to cross-examination. So I tried to expose that And I think I was quite effective in doing so. Then on points of law, the college really didn't have much to say about our legal submissions. So I think overall we proved our case, and it's up to the court to decide whether, with all the mistakes the college and the tribunal made, whether there will be a finding of bias. And if there is, then the decision has to go on that basis alone.
Alexander elaborates further on the position taken by the CPSO throughout the hearing and how they appeared to be insufficiently prepared to refute his challenges of their original ruling.
The arguments, that they had already made at the lower level, that's not sufficient. When you're challenged on those arguments, you have to grapple and respond and explain why the challenges are inappropriate. And they didn't even try to do that. So halfway through the first half hour of their submissions, Justice Myers, who was presiding over the panel, stopped the lawyer for the college and said, are you going to get to the issues? Because they weren't addressing them. And then something similar happened with the second lawyer who spoke in the second half hour. And he raised a fundamental issue of law that I raised in my factum and said, well, what about this? And the college really didn't have a reply. So somewhat subtly, the court indicated that the college was not addressing the appeal case that had been brought against them. And so I don't think that their submissions were particularly effective or well received by the court in the end. The question that the court will have to grapple with is, insofar as I essentially decimated 90% of the college's case, what will the court do with the remaining 10% that the court might, or that the college would have the court rely upon? So if they really want to take away Mark's license, they could get him on a few technicalities on the margin. However, should you really rely upon technicalities on the margin when so much of the college's case has just disappeared? That raises a really big question regarding equity in the courts and what you mean by equity. So equity is about the overall justice of the situation. And there's a really a profound question here about how the court will weigh the evidence, or how it should weigh the evidence and the overall case. When the college's, most of the college's points have been dealt with and refuted. I can't say how the court's going to deal with that, but it's going to be challenging for the court.
Looking ahead, Alexander outlines what's next, whether the case succeeds or not.
Well, if we lose, Dr. Troese can appeal to the Ontario Court of Appeal. However, the court doesn't have to hear the appeal. A special application has to be made, and the court will make a discretionary decision about whether to hear the appeal. So the right of appeal is not automatic. If we win, we will have established a new case law in this area that will roll back the authority of the health colleges in Ontario. And I think it will also generally roll back the authority of the administrative state in the province. So I think it will have a huge ripple effect. Also, if our arguments around free expression are accepted, we will have established a more comprehensive and a more grounded way to look at the freedom to express a minority opinion, which is guaranteed under the right to free expression in the Charter. So if they rule in our favor, regarding this point of law, it could have an impact across the entire country. And it could lead courts to enforce the right to freedom of expression in a more rigorous way. So potentially this case could affect cases all across the country, and it could affect the way in which citizens conduct their daily lives. They could end up with more freedom as a result of the Troese decision.
Alexander leaves with some final thoughts, including specifics around his cross-examination of one of the CPSO's supposed experts.
It's very important to focus on what Dr. Gardam, the college's main expert witness on COVID science, what he said. Because he said that what Dr. Trozy suggested about the shots, that they weren't safe and effective, and that there were other treatments available, such as ivermectin, hydroxychloroquine, and so on. He said that Dr. Trozy's position on that was beyond reasonable scientific debate. But at the same time, he did not say that Dr. Trozy had breached a scientific consensus. And this was clarified in his cross-examination. And during cross, he admitted that Dr. Trozy is simply espousing a minority point of view. He also admitted that there are majority views and minority views, and that often the truth begins as a minority view and someday becomes the majority view. So he essentially testified that Dr. Trozy's view of the world might someday become the majority view, or perhaps even a scientific consensus. So, the issue we put in front of the court is, can you penalize somebody simply for expressing a minority point of view? 80 years of constitutional law says that you can't. So if we are vindicated on this point, that means that doctors in this province will never be muzzled again by the College of Physicians or the Ontario government, because it will be affirmed that they have a fundamental right to advocate for alternative treatments based on a minority view, which will be legitimized. And I should note here that under Section 5.1 of the Medicine Act, every doctor in Ontario has the right to employ non-traditional treatments, as long as the risk profile for those treatments is no greater than the risk profile for traditional or conventional treatments. So that aspect of the Medicine Act has just been completely ignored by the tribunal and the college. So this is another aspect of the case that could help doctors. So if we get the free expression and the minority view argument through, and we have it affirmed that Section 5.1 of the Medicine Act has meaning in the practice of medicine, it will liberate doctors throughout the province.
Join us in calling for no more shots at nomoreshots.ca. At that website, you can sign our petition, and you can also send a form email to the Federal Minister of Health, Mark Holland, calling on him to revoke market authorization for these novel injections. All of that and more at nomoreshots.ca.